Annulment. Annulment, a remedy provided by law for reason of public interest for the declaration of the inefficacy of a contract based on the defect or vice in the consent of one of the contracting parties in order to restore them to their original position in which they were before the contract was executed. Party entitled to bring action to annul Article 1397 or 1397. The plaintiff who must have an interest in the contract. Article 1397, the general rule, the action for the annulment of contracts may be instituted by all who are thereby obliged principally or subsidiarity. However, persons who are capable cannot allege the incapacity of those with whom they contracted, nor can those who exerted intimidation, violence, or undue influence, or employed fraud, or caused mistake, base their action upon these flaws of the contract. The next is period for filing action for annulment, Article 1391. In case of intimidation, violence, or undue influence, 4 years from the time the intimidation, etc. In case of mistake, fraud, 4 years from the time it is discovered. In case of contract entered into by minors or other incapacitated person, 4 years from the time the guardianship cases. The action for annulment shall be brought within 4 years. The period shall begin in cases of intimidation, violence, or undue influence from the time the defect of the consent cases. Under Article 1391, the Civil Code, an action for annulment of a contract must be brought within 4 years. In Associated Bank versus Spouses Justiniano S. Montano Sr. and Ligaya Montano, the Supreme Court ruled under the circumstances of that case an action for the annulment of a sale contract based on the threat and intimidation allegedly committed by cronies of then President Marcos may be brought within 4 years from the February 21, 1986, when President Marcos was ousted from power. In Associated Bank, the respondent claimed that Tres Crosses Agro-Industrial Corporation was only forced to sell the properties to ICCI because of threats and intimidation allegedly employed by Marcos cronies upon the relatives of the Montanos while the latter were on self-exile outside the country. The Montanos filed the complaint on September 15, 19. Next is duty of mutual restitution, Article 139A. If the contract is annulled, the parties, as a general rule, must restore to each other the subject matter of the contract and the price thereof with a legal interest. In personal obligation, where the service has already been rendered, the value thereof with the corresponding interest is the basis for damages uncoverable from the party benefited by the service. Excuse me. Article 1398, an obligation having been annulled, the contracting parties shall restore to each other the thing which have been the subject matter of the contract, with their fruits and the price with its interest, except in cases provided by law. Mutual restitution is required in cases involving rescission under Article 1191. This means bringing the parties back to their original status prior to inception of the contract. Article 1385 of the Civil Code provides. Next is restitution by an incapacitated person, Article 1399. This is an exemption of the general rule of mutual restitution laid down in Article 1398. Incapacitated is obliged to make restitution only to the extent that he was benefited by the thing or price received by him. Whether or not the capacitated party has benefited from what he received from a minor, he must return the same except when he received the thing from the minor in the performance of the later natural obligation, and what had been received had been spent or consumed in the good faith. The next is effect of loss of thing to be returned by the guilty party defendant, Article 1400. If the thing to be returned is lost without the fault of the person obliged to make restitution, defendant, there is no more obligation to return such thing, but the other cannot be compelled to restore what is virtue to the degree of annulment he is bound to return. If it is lost, through the fault of the person obliged to make restitution of defendant, his obligation is not extinguished but is converted into a condiment for damages consisting of the value of the thing at the time of loss with interest from the same date and fruit received from the time the thing was given to him to the time of its loss. Article 1400. Whenever the person obliged by the degree of annulment to return a thing cannot do so because it has been lost through his fault, he shall return the fruit received and the value of thing at the time of the loss, with interest from the same date. The obligation having been extinguished by loss of thing, creditor shall have all the rights of action which the debtor may have against third person by reason of the loss. The next is effect of loss of the thing to be returned by the innocent party, paying thief. If the person who has the right to institute an action for annulment will not be able to restore the thing which has may be obliged to return in case the contract is annulled because such thing is lost through his fraud and fault. His right to have the contract annulled is extinguished, Article 1401. If the loss is not due to his fault or fraud, there is no annulment if the party cannot restore what he is bound to return. This is true even if loss is due to a fortuitous event. Article 1402. If an innocent party asks for annulment but the thing is he is supposed to return is lost by a fortuitous event, there may still the restitution provided he offers to give the value of the thing lost, but he doesn't not have to give interest if the view of the fortuitous event. Article 1401. The action for annulment of contract shall be extinguished when the thing which is the object thereof is lost through the fraud or fault of the person who has right to institute the proceedings. If the right of action is based upon the incapacity of any one of the contracting parties, the loss of the thing shall not be an obstacle the, to the success of the action unless said loss took place through the fraud fault of the plaintiff. And the last topic about annulment, effect where a party cannot restore what he is bound to return. When a contract is annulled, a reciprocal obligation of restitution is created. The return by one party of what he obliged to restore by decree of annulment may be regarded as a condition to fulfillment by the other of what is incumbent upon him. See Article 1191. In effect, there will be no annulment if the party cannot restore what he is bound to return. This is true even if the loss is due to a fortuitous event. Article 1191 or 1191, the power to resign the obligation is impelled to reciprocal ones. In case of the obligatory should not comply with what is incumbent upon him, the injured party may cause between the fulfillment and the rescission of the obligation with the payment of damages in either case. And that's all. Thank you.